Good morning.
Good morning, Mr. Chief Justice, and may it please the Court. My name is James O'Leary. I represent the appellant, the Massachusetts Teachers Retirement System. Your Honors, CRAB committed an error of law when it found that the statute before you today was not ambiguous, and it also failed to conclude that the MTRS's regulation reasonably resolved that ambiguity. And of course, that is the standard from Goldberg versus Board of Health of Granby.
What do you say to the argument that CRAB makes that the authority of the Teachers Retirement Board to make regulations that get approved by PIRAC is really about the sort of administration, I take it more numbers than that this doesn't fall within that particular, the purview of what your regulatory authority is?
My response is that isn't in the statute that the legislature, when the legislature says that the boards shall have the authority to issue rules and regulations, it doesn't seem to indicate that that's some sort of subspecies of the ability to regulate. The authority to issue rules and regulations is given to the 106 different retirement boards in the state, subject to PIRAC approval. PIRAC's role...
The role of CRAB.
CRAB's role is as the adjudicator of claims, as is clearly articulated in Section 16.4.
Doesn't it have a statutory responsibility to administer the retirement laws? Is that not part of what it says in the statute?
The CRAB's role, as stated in Section 16.4 by the legislature, is to, when there is a party has a dispute with a decision of the retirement system, the retirement boards by the legislature are given the obligation to administer the retirement system with PIRAC's assistance, and PIRAC is the one that's given the role in reviewing the rulemaking, the regulations, not CRAB. So CRAB's not in the business of invalidating regulations as far as I can read the legislation. What Section 16.4 does is puts CRAB in the position of adjudicating specific claims.
But if we agree with CRAB that the statute is not ambiguous,
I lose. If you agree with CRAB that the statute is not ambiguous, yes, the statute, but that is a de novo determination. Okay. That's a question of law. If the statute is not ambiguous, then as we state in our brief, okay.
And CRAB could make that determination as it did in an adjudication.
Yes, but it's not necessarily entitled to deferential deference, gotcha. Because it is a question of law that's reviewable by you de novo. And CRAB, in its decision, CRAB gives no basis for its determination that it's not ambiguous. In fact, CRAB is the only party in this case that thinks that this decision is this regulation is not ambiguous.
Reading it, there is one way to read it, not the way you read it, and that is just to look at it as a way of defining how you determine the buyback in a context of an employee who is not a former teacher. You compare it as though it's an important difference to the teachers in other states or to teachers who hadn't received something or other that permitted them to be part of the system. Here, we are talking about an electrician whose income may be earned in a variety of different ways. So you can't look to the monthly amount because it would be so varied or non-existent in particular months. And so what that statute seems to say, and you could argue clearly and unambiguously to say, is in these circumstances, we'll start with a particular year and then look back every 3 years and calculate it as a 10% of the total income for that year. That's the buyback. And then you apply the rest of the statute, which is there interest?
Well, what it says is make-up interest for each of the years purchased plus buyback interest. So there is language in the text of the statute that is susceptible to being read to say that the buyback, the make-up payment, and this is what we argue in our brief, the make-up payment is the way that the legislature is telling us that make-up is to be applied on each of the years purchased plus buyback interest thereon on that purchase. Interest is in itself a replacement for the return of investment that the retirement system gets on contributions when they're rendered. So those payments from return investment is what we use to pay the benefits. So what that argument means is, what the legislature is saying is that these non-public employees can purchase 1977 through 1980 service, non-public service as an electrician for less than teachers who were working during that time can, with interest calculated in 1988. That doesn't seem to be, if the legislature could do that, but it doesn't seem to be the language that they would choose to use. Also, bearing in mind that the legislative history of this provision, this was passed over Governor Romney's veto, which specifically called into concern the cost of this provision. Plus, there's a 6-month, at the conclusion of this section, there is a 6-month deadline. So it's not exactly supported by the other considerations. The theory of buybacks, this would be the only buyback provision in all of all of Chapter 32 that would do something like that, except for veterans that get it free.
Can I ask you 2 questions? Number one, 3 questions. Number one, was there any change to the legislation after Governor Romney sent it back?
I don't know the answer to that question, Your Honor.
Okay. Number 2, is do the teachers, other teachers, which have different statutory language, do they also have a requirement that you can't apply until you've been there for at least 10 years?
10 years also is in the Peace Corps in 401R. There are provisions. There are caps that.
Yeah, is that right?
I'm sorry?
Not the teachers.
Well, that's teachers. Yeah, it's a teacher's buyback provision. But
that's counting Peace Corps time. That's not in other systems. Is that right?
What that says is you have to be a member of the teacher's retirement system for 10 years before you can make that purchase. Gotcha. They all include some kind of either a waiting period or a cap, so that the waiting period of 10 years is most likely there because that's the minimum amount of time to vest for retirement benefit. So you wouldn't want somebody able to come in and just buy a retirement benefit. The other sections, such as 401P, which permits the purchase of non-public school service, has a cap that you can't buy more service than you've rendered, so it has to match up with your public service.
Do you have to wait 10 years? Do you have to have 10 years of service as a teacher as a member before you can buy back that service?
Not under 401P. It's the only 2 that I know are 401H&a and 401R,
which is the Peace Corps?
Yes.
Last question.
Okay. Thank you. I appreciate it.
I don't promise, but I'll try it. Anyway, what do you do about the fact that the other provisions really have very different language about, that explicitly bring you back to the period of other service that's at issue, that you're buying, and this one doesn't? Well,
I have a few answers for that. We think, of course, that the legislature has provided that language with the words "make-up payments for each year of service purchased." We think it's just another way. It's perhaps not as explicit, but what we're talking about is 9 different provisions to buy back teacher service out of 25 different in section in the statute that permits service purchases. In section 3 and 4, there are like 25 different service purchase provisions. So 9 of which apply to teachers. It is a rule of statutory construction that where the legislature has included language in one place and not included in another, it's to be presumed that they knew that. There are other rules of statutory construction, however, and we think that, but to take this single rule, as Crabb does in its brief, and say that in this disharmonious way with all the other service purchase provisions, you'll discount this type of service as opposed to membership service is unlikely. It's the eccentric reading, and we think that the interpretation that the regulation gives to the provision, the statute is at least susceptible of that reading. So we think that each of these sections says something a little bit different. There are different waiting periods. There are different amounts of service being purchased. There's Peace Corps service. There's different kinds of professions that are allowed to be purchased. So we don't necessarily think that while the legislature is, of course, aware of the other provisions of the statute when it's putting this together, we don't necessarily think it was modeling it on that.
Where there are roughly 25 different service purchase statutes, could PURAC essentially say we are going to clarify each and all of them with regulations?
Well, the retirement boards are the ones that are given they could give you know I think that the larger question is that there are 106 different retirement systems in the state. The legislature seen fit to create 106 different retirement systems, and yes, it could. There are different needs that drive the decisions of the state retirement system, which manages, as well as the Chapter 32 system, a defined contribution plan, as opposed to the teacher's retirement system, which is the only system that's not also the municipal employer of its members, to the local systems that have their own needs. So it is possible, and the legislature is quite clear that the retirement boards have the power to make law, to issue regulations.
So
it's not circumscribed.
With regard to this, I gather the MTRS is the only retirement system that governs teachers, correct?
Well, the state Boston retirement, you do have, I believe, an amicus was filed by the state Boston retirement system, and the state Boston retirement system is, teachers' retirement system has all the teachers in the state except for those in the city of Boston. So and they do exactly what we do. They interpret it the same way that we do.
Now, what if now? But you're saying that they could interpret it differently. They could put forward regulations which would have a different interpretation.
If it was rational, if it was susceptible, if that regulation was susceptible of being read that way and was rational under the Goldberg standard, yes.
So you would have the same statute interpreted differently by two different retirement systems administering that same statute.
Well, PARAC is the protection against that. PARAC is the agency given that role by the legislature, not CRAB, to make sure that the regulation conforms to laws and regulation. And that's what PARAC's role would be to prevent that Wild West scenario that you're envisioning there, that we'd have multiple different interpretations of the same provision. That's what that's the system the legislature has set up.
So on this question of who gets deference, you're taking the position that you get deference because you promulgated the regulation that controls in this case.
Well,
what's throwing me off a little bit is that we have cases that say that CRAB should be given deference. Are those cases different than this case?
Let me begin with the question that we don't think that part of the case. This case we think can be dealt with on the ambiguity question. If it's ambiguous, then the regulation fills that gap, and CRAB should have, and CRAB seems to recognize this in its decision. I'll get to that, but where there was a gap in the statute, the board filled the gap, and where there's a question of deference, you should go with the agency that the legislature is given the ability to make law. CRAB is in the business of adjudicating claims. If there had been a question of how this statute with its clarifying regulation was applied in a particular case, yes, then it's a deferential standard review. The Superior Court, for its part, sort of does both. It recognizes the ambiguity, and then it incorrectly defers to CRAB. What it should have done is applied the MTR's regulation to clarify that. So we don't think that this somehow affects CRAB's deferential standard review in adjudications. But where there's the question is, if the statute was ambiguous, the focus under Granby is to focus on the process, whether or not this was based on a permissible regulation using correct process for promulgating regulation. There's no question that that is what occurred here. Nobody's disputing that. So
Mr. O'Leary, you're going to have to start to wrap it up. Your time is up.
thank you. Well, in closing, Your Honors, the MTRS did nothing in this case but read the statute in a way that was susceptible to be read, and similarly to the other similar provisions around it. Did so by following appropriate protocols for issuing a regulation, making sure everybody would be notified, and still did it in a way that was still ended up being a pretty good deal for the member. Thank you very much.
Thank you.
Good morning, may it please the Court. Assistant Attorney General Kirk Hansen on behalf of the Contributory Retirement Appeal Board. Quite simply, under the traditional rules of statutory construction, and frankly under the first prong of Goldberg, Crabb's decision and the Superior Court's decision should be affirmed, because using all those rules of statutory construction, it's clear that the buyback interest under Section 41H1/2 does not go back to the years of service being purchased. It only goes back to the most recent date of entry into the system.
So you do agree that if we conclude that the statute is ambiguous, Crabb loses?
No. There are multiple steps, Your Honor, that would have to go through. First, the question is it ambiguous or not? We believe that it's unambiguous.
And why is that? What's the language that you focus on when you say buyback interest thereon? Is that the key language?
Well, no, Your Honor, it is that you have to look at the statute as a whole. Again, in interpreting
I have, but...
And the point is that, as my brother noted, there are several different buyback provisions for various types of service. And in all of those except H1.5, the legislature saw fit to make clear that the payment you make goes back and represents what would have otherwise been contributed had you been a member during the years of service being purchased. That language is expressly absent in H1.5. And under a traditional rule of construction, when language is absent in one location but used elsewhere, courts do not read that language in where the legislature saw it to not include it.
So you're saying the statute is unambiguous because of language that is not in the statute,
When read as a whole, yes, Your Honor.
but read in the context of other statutes.
Well, we look at the statute as being all of Section 4, not just the subsection. You can't read just the one subsection or one sentence in that subsection to determine if the language is clear.
Right, but the one problem with your analysis is that the other statutes focus on the amount earned at the earlier time period, and this statute makes it quite clear that it's the first year of being a teacher that matters. They use they go back in time.
Well, I would also then point, Your Honor, to Section 4.1R, the Peace Corps purchase, where the amount that is used for the buyback is based off of the most recent date of service, not what was being earned, if anything, during Peace Corps service. But then the legislature also added the language saying that that amount is supposed to be what would have been contributed had you been contributing while doing the Peace Corps service. So
Doesn't that, by definition, if you're looking to 4.1R or 4.1P or 4.1 whatever, other than H1.5, seems to me that you have to be saying that it is somewhat ambiguous, because you don't go outside of the language of the statute if it really is unambiguous.
well, I suppose then, Your Honor, it's a question of what is the statute. Crabb's
well,
position is the statute is all of Section 4, not just H1.5. Certainly there's nothing, but there's nothing in H1.5 that says that it should go back to the years of service being purchased, we don't believe.
So even if the statute, if we don't agree with you and the statute is ambiguous, if we conclude the statute is ambiguous, tell us why we should still defer to Crabb.
Well, the second question is, are both interpretations reasonable? Crabb's position is that they're not. Only Crabb's interpretation would be reasonable. But then if you view both as being reasonable, then you get to the question of deference, to whom it's owed. Crabb certainly believes the deference is owed to it, not to
But why?
This is a very unique system, certainly, with retirement law. Goldberg says you defer to a regulation. The reason being is that regulation is promulgated by the agency that has primary responsibility for administering the statute.
Right.
With retirement law, Crabb sits above all the other retirement systems in adjudicating and interpreting retirement law so that you have a uniform and consistent application.
Okay, but if it was ambiguous, and if different retirement boards can promulgate regulations, if they've been authorized to promulgate regulations to flesh out the law, why shouldn't we look to the way it was fleshed out by the Mass Teachers Retirement System here?
Well, again, Your Honor, I think it goes to, as I said, if it is ambiguous and looking to it, you can run into a danger of having over 100 different retirement systems. Obviously here, there's only teachers' retirement and state Boston retirement that it applies to, but other buyback provisions can apply to all of these retirement systems. And
But why isn't that what PERAC is supposed to do? PERAC is the umbrella that sits on top of this. They can't promulgate regulations without them being approved by PERAC, right?
Correct. And simply, I don't know, Your Honor, what the review is that PERAC has done in this case, whether they look to compare it to, and in other situations, if they look to compare that regulation to all other regulations for one uniform interpretation. If there are multiple reasonable interpretations, you might have sections being applied differently in different systems simply based upon the
Does CRAB have statutory authority to promulgate regulations?
I'm sorry, does CRAB?
Does CRAB?
No.
Yes. Okay.
And did the MTRS have the authority to issue this regulation?
There certainly has not been any argument made that this was not in some way properly promulgated, so I don't believe.
Okay, so you concede that this is not an ultra-virus regulation?
I don't believe that it exceeds their authority. The statute that gives systems authority to promulgate regulations has a very broad language. But when it comes to the uniform application interpretation, I believe CRAB does have the authority to read it and say this is what the statute means. And if that regulation is contrary to the meaning of the statute.
But if they have the authority under the statute to issue the regulation, is it not, the usual analysis, legal analysis, is that we treat a regulation as a statute, and if it can be interpreted in harmony with the statute, if it's not essentially ultra-virus, the regulation prevails. Why should it be different here?
And again, that traditional analysis, Your Honor, I just go back to, it's because of the agency that promulgates the regulation has the primary authority for administering and enforcing the statute. And so in this case, it's not the 100-plus local systems that have the primary authority for administering and
Well, they
enforcing.
do, don't they? I mean, it only gets to CRAB if somebody doesn't like what they did. But I mean, in terms of the day-to-day administration, that's what they do.
If by primary we mean the initial, yes, but if we want primary to be like a sole, some overarching authority that makes for a uniform and consistent interpretation and application, it makes more sense for it to be CRAB, Your Honor.
Well, you say that, but if there's a written regulation that is to be used and apply with regard to the interpretation of retirement benefits, and if that regulation was appropriately promulgated and is not ultra-virus with regard to the statute, why should that not be honored? Why should somebody have to wait until there's an adjudication and CRAB then determines whether that regulation is to be governing?
I just think that, Your Honor, this is a very difficult area, certainly. It's a very unique situation. I'm not aware of any other type of agency setup that's similar to this, where you have an agency like PERAC that has the authority to approve the regulations. You have a separate agency, CRAB, that has the authority to effectively promulgate rules through adjudication to determine how those two match up for authority. Certainly, if we're giving deference to the regulations, you could have a situation arise where CRAB makes a ruling, and if a retirement system doesn't like it, they then turn around and promulgate a regulation to effectively overrule CRAB's interpretation. I think if the deference is being given to these regulations, it does create a possibility for, I don't know if havoc's the right word, but just difficulty in the application and uniform interpretation of retirement law.
Now, what do you say to the MTRS's argument that there is adjudicatory deference to which CRAB is owed, but rulemaking deference to which the MTRS and PERAC is owed?
Again, I think it becomes a very difficult breakdown, Your Honor. I think, obviously, this court will, if it feels it needs to determine the deference issue, we'll have to figure out how that goes. I believe, though, it should be for CRAB. Certainly in other cases where PERAC and CRAB have been on different sides of the issue, I think this is the first time it's ever happened in the context of a regulation, but certainly in other areas, this court has basically, I think, either said they gave deference to both. I think of the
We've avoided it, as far as I can tell.
or decided it did not need to be reached. The Palazzi case, the Rotundi case that have come down recently. And so, again, I certainly don't believe you need to reach it here, because I think applying rules of statutory construction, this is simply a different animal with this particular section, H&1/2. The legislature has chosen in other instances to apply something different. For example, in 41H, which is the purchase of armed services, they chose to have no buyback interest applied. They also chose that you didn't have to wait even 10 years to make the purchase. You can make a payment at any point in time, tied to, I believe, to a date of service in the actual retirement system. And clearly that's not in the best interest for the fiscal integrity of the system, but it's a choice that the legislature made. The legislature here also made a choice. They chose to have the amount be tied to the most recent date of entry into the system. They chose to force somebody to wait 10 years to purchase this. So having 10 years of membership
You'll
service.
have minimum 10 years of interest.
Well, in almost all cases, yes, Your Honor. So there is already built-in buyback interest. It's simply saying you don't have to go back those 10 years of membership service plus an additional 3, or in the case of Mr. Walsh, an additional 10, because he chose to plan ahead and get certified 7 years before he actually started teaching. So given that they chose not to include the language saying that the buyback amount, the payment, reflects what would have been contributed in the years being purchased, when 3 years earlier they knew how to do it and did it in 41R, that this represents a choice by the legislature.
Chris, one of the problems here, though, is that the kind of service that's being credited was not really public service. It wasn't teaching service. It was private sector service. And it could have even been 10 years before the person became a teacher. So what the legislature did was tie it not to what the person was actually making, but to what teachers were making when this person entered the service. That still seems to leave leave room for tying interest to the 3 years to at least 3 years before the immediate 3 years before the person began working, or I'm sorry, the 3 years that the person actually earned the service, which could have been 10 years before he even became a teacher. And that's a tremendous amount of interest that could have been accruing and needed to support the retirement system.
Didn't you have to, wouldn't you, to count the years though, wouldn't you have to be certified? There's something you have to do, right?
What the statute says is the years that you're allowed to buy are the years that are necessary to receive certification from the Department of Education. I'm not sure how many years that is. It's limited to 3 years of that. So it's tied to when you become certified. Now, several teachers, I think, became certified once they started teaching. And so if they, like Mr. Walsh, had worked until 1987 as an electrician and then got certified in 1987, it would be those immediate 3 years. But Mr. Walsh was somebody who planned ahead, got certified in 1980, continued to work as an electrician. And so he was limited to buying the years of service that preceded when he became certified.
So it would be 77 to 80.
In 80, yes.
And if let's just say he started teaching in 87, I'm
Yes.
just trying to figure out how this works. And let's say he didn't get certified till he started teaching, as you said. So he would be limited to 84 to 87, and he would have to wait until 97 to seek to do that. Is
Correct.
that right?
And then there would be 10 years of buyback interest paid.
Okay.
And yes, Your Honor, I mean, the legislature could have tied the buyback interest all the way back to the years of service being purchased if they had included that language that is in 41R, 41P, all these other sections that have been briefed in our briefs, to make it clear that the payment ties back to those years of service. They chose not to do that here. And I think that difference is significant. So for these reasons, yes, we would ask you to affirm.
Thank you, counsel.